Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now this morning I'm looking at a book which has come to us from Sweeton Maxwell. It's part of the Thomson Reuters organisation, and this one is called Documentary Evidence. It's now in a 12th edition and it's been written by Charles Hollander, Queen's Counsel. It's a very important book. Evidence is such a misunderstood subject to many people. It's vital, if you're ever in practice, to do it. It should certainly be mandatory on the LLB courses. It isn't, of course, but it should be, in my view. But evidence is so important because that's how you actually succeed with your case. I think this book is particularly relevant also to expert witnesses as well, giving expert evidence, but we'll get on to that in a minute. What I've given the title of this book, I've said it's a must-have book for practitioners and judges. It's a definitive work on documentary evidence, now in a new edition, and I've written this together with my wife Elizabeth, and we've written it for a whole range of audiences, including those people who give evidence not just as witnesses but as expert witnesses, and it's all about the documentary side of that evidence, which is so crucial in modern advocacy because of the way the courts deal with the cases and the way that we have huge bundles of documents in order to sort out any case. Here is the book, black cover, hardback, spine, nothing on the back. Now we're going to the back of the book first of all. It's 572 pages. There's the index at the back, nice index, and the index is done again by paragraph numbering, and it sets out how it's the taxonomy is set out quite clearly, so you know how to find things. There's a lot of footnoting, as you can see, and you can see how the book is structured. The paragraph numbering is actually at the sides, a little bit like a law report to a certain extent, in that you can find things quite well, quite quickly, I think. There is the footnoting at the bottom. If we go right to the front, there's a lot of case law in this book. It's a very, very detailed book, and I think a first-class book. And Charles is to be congratulated on a brilliant new edition. There is a dedication, which is extremely important, in my view, for everybody. Then to know who it's dedicated to. Preface to the 12th edition, always worth reading. Been a while since this new edition came out and a few things have happened. So what you've got here, he says it's now 30 years since this book was first published, and he says certainly the litigator stuck in a time capsule since 1985 would struggle to recognise documentary evidence today. I'm afraid I'm of that vintage that would agree with him. There are a lot of changes. There's the table of contents. It's a very important book, I think, for practitioners, anybody involved in studying evidence. There are the contents pages. You can see the paragraph numbering. You can see a very large amount of information, litigation privilege, lots of privilege information, without privilege and so forth, waiver of privilege. Then you can see the experts, expert reports chapter 30, Civil Evidence Act 1995, then the table of cases, a lot of cases of course. Then after that we get evidence, of course, is very much table based. Procedural rules, there'll be statutes as well, very little I hasten to add on statutes, but a little bit, and there's also a little bit on SIs as well. But after that we then get some practice directions. That's creeping in now, which of course is extremely helpful to give some idea of pre-action conduct and so forth. Pre-action disclosure from the opposing party, chapter 1. And you see it runs on from there, straight in. We go straight into the protocols, which is, I still would suggest that a lot of people are not paying enough attention to protocols, but the book starts off immediately with that, so you know exactly where you are. And then you've got the Norwich Pharmacal Order, a very special area, which we will talk about in a bit more detail. There then is the book. I think it's an excellent book. It's up the very highest standard of legal books. It's not just a book for practitioners, it's a textbook. It's also a book I think anybody who's involved with the certainly doing exams, the bar student and the law society student, the trainee solicitor, trainee barrister, whatever you want to call them today. This book I think is very much a book. If they're going to ever do contentious litigation, it's certainly a book that they should be aware of and actually have read and had a good look at. Not necessarily cover to cover, of course, but certainly know where the contents are for any particular area where you have a dispute. Because, for instance, if you have a brief coming into chambers, there may be a very small area where you do need to have some advice, and I think you'll find it here, based on any dispute concerning documentary evidence. That is my own take on it as a practitioner, but I certainly think that would be of assistance. Now, what do we say of the book? Well, this is what Elizabeth and I say. Has the nature and practice of advocacy changed all that much over, say, the past generation? Well, yes, in the sense that it has evolved to the point generally where the written word as a matter of record tends to carry more clout in court than that which is spoken, and that's certainly what's happening now. As the get it in writing dictum is now preeminent, written advocacy and obviously the written document are now in the ascendancy, and rightly too, of course, in many ways, because you can't argue. You can interpret, but you can't argue with that actual piece of primary evidence. Hence the urgent need on the part of any advocate for this long established yet regularly updated work on documentary evidence. And of course it is important and it is urgent to be up to date with what is happening. The book's been published by Sweet and Maxwell, that's part of Thomson Reuters, and it's now in the 12th edition, which has come to be regarded as the definitive work on this complex subject matter. Effectively, it's been updated every 3 years and been around, as I've indicated, since 1985, which is a testament in itself to its authority and reliability as a most helpful friend. Now, the author, Charles Hollander, Queen's Counsel, has thoughtfully enumerated the major changes and updates in this new edition, and it's been published in the wake of the Jackson reforms, and it covers, for example, new developments in the areas of self-incrimination and limited waiver. Also substantially rewritten are the chapters on pre-action disclosure, which actually is right at the beginning, non-party disclosure and collateral undertaking, inadvertent disclosure, litigation privilege, that's more towards the middle end of the book, the fraud exception to privilege, without prejudice privilege, and much more, including the Norwich Pharmacal decision, which of course is covered, I think, and given a rightful amount of publicity in the book. It's worth noting that the number of chapters devoted to privilege is significant. You notice that by just flicking through the contents section, and privilege being identified, of course, as a fundamental right. There is additional new material on the rights of shareholders and directors to access company documents, and of particular interest, we think, to advocates dealing with expert witnesses is the section on expert reports. This contains commentary on the new expert rules, including guidance on instructing experts under the civil procedure rules. And I have to say, as a member of the Expert Witness Institute editorial board, I think it's very important that we get this across about the needs to comply all the time with CPR. It may be something that some are not quite as familiar with as others, so I think that's an important point to bear in mind, and this book does help in that area. And as you would expect with a work of this stature, there are extensive tables of cases, statutes, SIs, civil procedure rules and practice directions. It's logically organised as a text, I think. It's copiously footnoted and easy to navigate. Remember, you use the paragraph numbering. As I say, it's with the detailed table of contents, and of course the numbered paragraphs themselves throughout are what you use if you're looking at the index at the back, which I found again quite useful, because you do actually need to use both the front bit for content and the back for the index if you're trying to search for something specific. Again, you may be looking for a case and have forgotten the name, so that's one way around it. At least that's how I've done it. Now, recalling somewhat ruefully the trolley full cases full of documents wheeled into court, which are now a commonplace sight in most cases, this book is certainly a boon to all members of the legal profession in our view, including judges as well as barristers and solicitors, not to mention of course the expert witness whom I referred to earlier, all of whom will appreciate, I think, the clarity of Hollander's prose, its practical approach and its pithy insights and observations. Thank you, Charles. The publication date is cited at 2015. Here's the book again, you can see it, hardback, there we go, and the back of the book, let me just run back through it at the back. You can see there, that's actually electronic documents I've opened up at, again an important area, without prejudice as a cloak for wrongdoing. You see, there's an awful lot on privilege here, which I think is really quite helpful, because privilege, and with no question in my mind, that is an area which can be used as a cloak if you're not careful. Certain people, if I can put it that way, with negotiation. There's the table of contents again, and as I say, you can see just by looking at it, we get into privilege very quickly. In the book itself, I've been very, very impressed with this book. It's a very detailed work. The fact it's only got something approaching 570 pages belies the fact that there's a huge amount of detail in there, a lot of detail, and it's a subject. I've taught evidence at university level, and it's not an easy subject. People think they know about evidence and don't. This book, I think, will shatter a few illusions about what you know by looking at it and realising you don't know quite as much as you thought you knew. Thank you to all concerned, though. I found it a very useful book. It's certainly something, if you want to go for a first for your LLB, get this book. Thank you to all. Bye-bye.